So now we jump into this final session. Our speaker, Janet Cho, focuses her practice on intellectual property counseling, prosecution, and litigation. She represents clients in trademark, trade dress, advertising, domain name, and copyright matters. She advises businesses with regard to the registration and management of intellectual property assets, as well as licensing of such assets. Welcome, Janet.
Hi, thank you, Jen, and thank you, audience. I realize that I am the last presenter on a Friday afternoon, so I really appreciate your time and the opportunity to speak with you. And this is a topic that I really enjoy speaking about, so I'm very excited. Next slide, please. So I'm going to start with a poll question because I think this ties together some aspects of what I'm about to discuss. So I wanted to ask all of you, for those of you who have business before the United States Patent and Trademark Office, which I will interchangeably call USPTO or office, have you been experiencing extended wait times for any business that you may have? So please answer yes if it's been a little longer than normal, or yes if it's much longer than normal, either way, or no if you haven't noticed a difference. And I will give everyone a few minutes to answer because I know my answer, but I'm curious to know everyone else's answer. Okay, so I'm scanning the results, and I'm happy to say for most of you, actually, most of you have said no, that you have not noticed a increase, which I will say is the winning answer only in terms of prevalence. I think that for most people that I've talked to, both on the applicant and registrant side, as well as other attorneys who have business before the office, there has been an increase in wait times for everything. And you may have noticed, for those of you who have business before the office, once you file an application, it used to be that your application was put on file and made of record, and you'd get a little notice in your application saying, your application has been newly filed, it's waiting to be assigned to an examining attorney, and that will happen within 3 months. That was typically what would happen when you filed a new application, and that's been the case for a while now. And just this year, just a few months ago, that notice is now changed from a 3-month wait time to a 6-month wait time. And the office itself has issued communication basically saying, we are experiencing longer than normal pendency times. So it's been my experience that, business before the office on all levels, no matter what you're doing, whether you are waiting for something you filed to be processed, or you're just sort of waiting for the office to get back to you on something, it's just taking longer. And so I ask this question because it informs and will have an impact on what we're about to discuss. So next slide, please. So what I'm going to talk about today as a trend, and it falls into the subject or what I categorize as, are there any trademarks available? But before I get into some of these trends and the cases, I want to step back a little bit and say there are a lot of trends and a lot of cases percolating up in the realm of trademarks. And so given our time today, I haven't tried to list out every trend in every case. I've tried to select the things that I think you all as brand owners, or perhaps those just interested in trademarks, might find helpful and useful. If there are things that we discussed today that you want more details about, or there is something that I didn't discuss today, or a case that you've heard about that you want to know more about, or that you would like to discuss with me, please let me know. And I'm happy to share the case with you or make a statute available to you. So I do want to start with that disclaimer that we're not going to go through everything. There's just too much. It can be a whole day long affair. And before I get into trademark trends and cases, I wanted to just do a little bit of level setting and talk about what do we mean when we talk about a trademark. I don't have a slide devoted to this, mainly because I thought it would just be helpful if we, talked about it freely. And I think I have spoken about this to some on this call. So I just wanted to briefly say, when we talk about a trademark, what we're ultimately talking about is a designation of source. So a trademark can be a word, a phrase, a symbol or a graphic element, or perhaps a combination of those things. And that together is intended to distinguish your goods and services from another party's goods and services. The way that it works ideally is that in a crowded marketplace, whether that marketplace be a shelf in a store or on the internet or at a convention, when consumers see your mark, whatever that is comprised of, they immediately think of you. And a trademark is essentially a commercial tool that's helpful in doing two things. These aren't the only two things, but it's helpful in sort of creating this immediate mental connection between your business and the mind of the consumer. And it's also a really helpful tool to create goodwill between your business and the consumer. If a trademark is strong and well maintained, what should happen in the mind of consumers is that your customer should have a very, very favorable impression of you. So trademarks are, if they're useful, perhaps even almost absolutely necessary commercial tools in communicating with your customer. And the nice and unique thing about trademarks, unlike other forms of intellectual property, is that a trademark can potentially last forever. Here in the United States, unlike other countries, your trademark rights arise through use in the marketplace. It's not the trademark registration that gives you your rights. A trademark registration is a helpful enforcement tool. And if you are planning to use your mark for an extended period of time, or you have a mark that's extremely valuable to your business, I would recommend considering registration. But your use is really what gives you your rights. So as long as you continue using your trademark, you will have rights in it. If you happen to have a registration for your trademark, your registration can subsist potentially forever as well, as long as you keep renewing it, and your renewal is dependent upon your use. So a trademark, or another way I like to refer to a trademark as a brand, your brand is very, very helpful to get your message across to your consuming base. Next slide, please. So what I want to talk about is this concept of, are there any trademarks available? And by that, I mean trademark depletion, which I will speak about first, and trademark congestion. And I will say the depletion and congestion terms may be a little bit misleading, and there are some overlaps, but it's basically this notion of, broadly speaking, what's available to you as a potential party or a potential business seeking to use or register a mark. And a funny story, how I got really interested in this subject matter is, I actually had a client, and this is already 3 or 4 years ago, and we were discussing a trademark that they were interested in launching with. And it was a product-based trademark. And the client had spent all of this time and energy and resources trying to develop something that they ultimately thought was very, very unique in the marketplace. I think they even hired an advertising company or a brand consultant, something along those lines, to choose something, not necessarily that was coined, but something that they thought was very, very unique, only to find out through their own process that they actually were not as unique as they thought they were. And so as I was speaking to the client, he blurted out, "I feel like there are no trademarks available anymore." And we had a really, really good laugh about that. But since then, this notion of what's available to use as a trademark has become the subject of very, very serious academic study. There have been a host of law review articles and academics who've written on this as to whether or not depletion and congestion are real. What does it mean? How does it play out? And what can you do about it? So I'll start with depletion first. And what trademark depletion is the phenomenon by which there is a shrinking number of words or phrases or combination of words that are unclaimed or available for use in registration. And I'm solely speaking of words. I'm excluding graphic elements or designs and those kinds of things that have no connection really to word elements. But this is similar to what some call natural resource depletion. Technically speaking, there should be an unlimited number of words and combination of words that should be available for use as a trademark and available for registration as a trademark, but that is not actually so. And so as a brand owner or someone who's thinking of launching with a brand in the marketplace for a particular product or service, you may find that unless you've actually come up with something, a word that doesn't exist in the English language, which is known as a coined trademark, unless you come up with something just that original or just that unprecedented, you may find that you are precluded from using your mark or potentially registering the mark. So it's definitely something to think about, and it can have real world consequences in terms of the expectation you have for a mark that you're looking to launch with. If you've already invested time in developing the mark, or maybe even building employee morale around a particular mark, this can be very, very problematic, and it can lead to certainly time and money that's not well placed. Now, depletion is different from congestion, and I will speak about that in more detail, but congestion is a separate phenomenon where one mark is said to be or claimed to be owned by more than one party. And that could be a situation where the mark is used for the same or similar goods or services, or that one particular mark is used for a host of different goods or services. Next slide, please. And I will say for trademark congestion, just to give some color to the depletion definition, I will say a good way to think about trademark congestion is what some might call commercial dilution, where your mark is weak. And why that's important is, first of all, very often you as brand owners want to enter the marketplace with a mark that's very, very distinctive, meaning you're the only party using that particular mark, at least for those goods or services. Maybe there's someone using the same mark for a good or service that's unrelated to you, and you have less of a concern about that sort of scenario, but you really want to make a splash in launching with something that no one else is using. Well, very often, or what is now the case, is and this definitely occurs in the unregistered trademark realm. You may decide that you want to use a mark, say, for example, ABC Laundry. You want to launch a business where you operate a chain of laundromats under ABC Laundry, and you find out that there are a host of relatively small businesses across the country operating as ABC Laundry. Now, they are unregistered marks, and they don't necessarily have any geographic overlap with one another, but they're out there. So you're essentially joining a very crowded marketplace. And if you are a party that's just basically interested in using a mark, and you don't have any concern about how crowded the marketplace is before you, then that is likely acceptable to you. However, if you're a party that wants to join the marketplace without complaints from others, and then in turn stop people who come after you from using ABC Laundry, then that crowded marketplace is going to work against you, because that junior party after you is essentially going to say, well, you came into a crowded marketplace and things seem fine. Why can't I do the same? So congestion really not only erodes the distinctiveness of a mark, but it also can prevent you from effectively policing your mark. So with that, I wanted to give you some examples of what we're talking about when it comes to depletion. And I mentioned congestion along there because there is some overlap between depletion and congestion. It's not always clear whether we're in the depletion or congestion realm, but I want to share some facts with you. And I typically don't like to read facts straight from a PowerPoint, but I think these are important facts. So in a Harvard Law Review study, it found that 81% of the 1,000 most commonly used English words have already been registered as single word trademarks. 62% of the 10,000 most commonly used English words have been registered as single word trademarks. And of the 1,000 most commonly used words, the ones that remain typically have, and I'm using negative here, negative connotations. And I realize negative is in the eye of the beholder. So, what is negative in one brand may be very positive for another. But I say that to say, more so than whether or not something's actually positive or negative, what this type of scenario creates is that you may end up having to, you may have spent some time and money investing in developing a brand for launch, and then come to find out that you have to switch gears. And so you are now having to look at perhaps your second or third or fourth tier of choices, if you have any, to look at in terms of use and registration. And Also 55.4%, so over half of the surnames most widely used in the United States have been registered as trademarks. And there are many, many examples of how depletion can affect a business in the real world. There has been a study, actually, in addition to this Harvard Law Review study, there's been a study of marks and names used by companies in the brewery and the alcohol business. And apparently businesses in that industry like to use either geographic place names for marks or monument names like Mount Rushmore or something, or mountain ranges or something like that. And I think something like over 80% or a great proportion of at least geographic place names have been taken by those in the alcohol industry. And so if that's something that you were thinking of doing and this is your business, then this might be the time to potentially switch gears and choose a marker name that doesn't have a geographic or a monument significance. And there's also a phenomenon within particular industries where, depending on what's going on in that industry, certain terms and images become very popular. So there was a time in financial services where the term and images relating to this term were really popular. So one was compass. So the word compass and images of compasses, lighthouse and images of lighthouses were also really popular. Navigator as a term was also really popular. And what happens is, if there's a particular development in an industry and a party decides they want to choose a mark that really speaks to that development, then oftentimes other parties in that space want to join that messaging around that particular, if one company is doing it, we want to be in on it too. And you can imagine in financial services, in a turbulent time, these things such as compasses, navigators, lighthouses convey some direction or convey a beacon in darkness or disorganized times. And so that can happen as well and contributes to depletion and congestion. So really, one thing I would definitely encourage everyone to do as they're thinking about not only your current brands, but brands that you're thinking of launching within the future, is to make sure that you have some flexibility in terms of what you're choosing. I know oftentimes it's been my experience that a company has one or two things that they're really, really wedded to, and you get really excited about that. Going forward, it may be the case that you may have to choose 3 or 4 or 5 things that you're really excited about, or have a good list of alternates that you may consider as your brand. Next slide, please. So going to impact, some of which we've already discussed, but as you think about depletion and congestion, should you come across a depletion or congestion scenario in your mark selection or your mark process or your brand process, what should you do? So again, be flexible and be prepared to move off from something that you've selected if necessary. And also, you may have to be prepared for the fact that when you file an application, things that maybe took 6 months or a year, as we discussed at the very beginning, are going to take longer. I know that it used to be, when I first started my practice, we were telling applicants that, it's probably going to take a year from filing to grant of registration for your trademark. And that was, over a decade ago. I think now, with the increased pendency time at the office at the USPTO, a year is really just kind of the time that you're waiting for things to happen. Now, depending on your mark and what goes on and how quickly you respond to maybe rejections that come along the way, you can increase that timeline. But definitely, I think gone are the days where you could only need to wait between a year between filing and grant of registration. And also be prepared for the fact that the USPTO register is going to be more crowded. And so if you are a party or you're a business that tends to look at, say, the USPTO's public database, just to do some informal or maybe some initial searching for a mark that you're interested in, you may find that you're spending a lot more time looking through the public database and having to make some more nuanced decisions as to whether or not the marks that you come across pose risk. And also, and I think this is kind of implicit in what we've discussed, but there's definitely going to be increased cost for searching and filing for proposed marks. How that comes about is, again, whether or not your due diligence is informal, where you're just looking on the internet or looking at the USPTO register, or you're actually commissioning a trademark search, most likely you're going to have an increased list of citations that you're going to need to get through to figure out what kind of risk your mark poses. And so that's certainly more time and cost as you make these decisions in terms of how much risk a third-party mark poses. But also, in terms of filing costs or USPTO costs, how that can arise is you may be a party that's found something on the USPTO register that you think potentially may be problematic, but you want to proceed, knowing the risk. And so you file for a mark that's maybe already pending or registered, but in a different class or for some different goods or services on a prior application or registration. And so to increase your scope of protection, you file in a host of different classes, or you add to the goods and services that you've claimed, both to increase your scope of protection, but also maybe to keep yourself away from a third-party mark. And so that can increase your USPTO filing fees and your costs. And again, this also adds to the time involved in terms of what you want to file for and what you want to protect. Next slide, please. So this slide is called What Can Be Done. And what I will say is, this is not necessarily what can be done on our end, either as practitioners or brand holders. This is really some things that can be done at the government level or maybe at the statutory level. So these are some things that partially have already been done and also that are in consideration to deal with depletion and congestion. One is increasing maintenance and renewal fees. There is a thought that by increasing fees generally, that you will have applicants before the USPTO. You will only have applicants who are really serious. So sometimes you have parties that may file applications just to see if they're not maybe using the mark, or it's not clear that they have true intentions of using, but you file an application just so that no one else can file. You're essentially blocking someone else. And the USPTO, I think every trademark registry, typically does not want to see that kind of conduct. And so there's a thought that if you increase fees, you only get sort of serious and invested applicants and registrants. So that's one thing that is being thought of. And there have already been an increase in fees in certain actions before the office. For those of you who do business before the office, you may have noticed that one thing that the USPTO has done is now they levy a fee for deletion of goods and services. That didn't used to be the case. If you wanted to delete something from your description from an application or a registration, you were just able to do that through an amendment. And typically that amendment didn't come with a cost, because the USPTO wanted to encourage applicants and registrants to keep records as clean as possible. They had this anti-deadwood policy, and so they wanted to encourage the public to get rid of deadwood, meaning the things that you're not using your mark for. They wanted to make it really easy, so there was no fee associated with deletion. But now there is actually a deletion fee. So I leave it to, I'm agnostic on whether or not what the impact of fees do, other than actually just increasing the cost with maintenance and renewal. But that is one thing that's being considered. There's also some discussion of elevating how strictly use is assessed. And for those of you who don't have business before the USPTO, one of the requirements in order to obtain a registration in the United States is that you have to prove that you are using your mark before a grant of registration will issue. And in order to renew a registration that's been granted to you, you have to prove use at certain periods along the way in the life of your registration. And I think informally, the strictness of the use requirement has been elevated, but there is consideration of sort of more officially increasing the strictness of the use requirement. Also just reforming our U.S. Trademark Act, the Lanham Act. And then perhaps one of the more interesting considerations is having our USPTO system become more similar to the European Union Intellectual Property Office. So if you file an application at the European Union Intellectual Property Office, or the EU IPO, what happens is your application is examined for, to make sure that it's sufficiently registrable, that you filled out your application properly. But the EU IPO actually does not refuse applications on the basis of a confusing similarity with someone else's registration. The EU IPO's philosophy, or their position, is that is what trademark oppositions and cancellation proceedings are for. If you have a problem with someone else's application being registered, then you, as a prior registrant or applicant or interested party, can come to the EU IPO and challenge an application. It is not going to be the EU IPO's position to affirmatively refuse. Now, the EU IPO will notify the party, the prior registrant, that someone else has come along and is filing an application for something similar, which is not something our USPTO does. The prior registrants get no notice that someone else is filing for something similar, at least from the USPTO. But the EU IPO will do that, and if the party opts to challenge that application, they can. So that's an interesting development. We are not there yet, but these are all things that are sort of under consideration to deal with the phenomenon of depletion and congestion. And a few other things I just wanted to mention in the interest of time, and I'm happy to discuss this at length via questions or outside of this CLE, but there are a few other things that I just wanted to make others aware of that I think are really, really important in terms of those of you who are interested in brands and want to maintain brands. Is, in addition to the depletion and congestion phenomenon, there's something called bad faith filings that has occurred, and it's a really, really big deal before the USPTO right now. For those of you who may have applications and registrations in countries outside of the United States, you may be very familiar with this phenomenon, but a bad faith filer is typically someone who files a trademark application that they really have no interest in. It's not something that they're using. It's not a mark that they actually, intend to perfect, but it's typically the mark of a pre-existing business, very often a well-known business. So it's as if I went to Spain and decided to file an application for Nike. And what the hope is, this isn't the only reason, but very often what the hope is that applicant is going to try and block the real Nike from filing their application, knowing that Nike has to have a trademark application in Spain, or any other company, not just Nike. I'm just using them as a company that I think we've all heard of. But it's their hope that when that well-known company decides to file their application and they get blocked, they can leverage that application, or if it becomes a registration, they can leverage that application or registration to say, I know you've been blocked by my application or registration. I'm happy to sell my application or registration to you so that you have a free and clear path to getting registration. So that's been going on, I think, in international jurisdictions for a while now. And part of the reason that can occur is that in many jurisdictions outside of the United States, you are not obligated to show use at the time you file your application, and you're not obligated to show use before a registration will issue. Your use requirement comes after registration. And so pretty much anyone can file an application because, there's really nothing much that you have to invest. And so that's been going on for a while. And now that phenomenon has now come to the United States, where there are parties, just a whole host of parties. Very often the applicant themselves is based outside of the United States, and they're looking to do the same thing here in the United States, given the depletion and the congestion. And so if you find out that, you want a mark and someone else has it, but, perhaps in order to clear your way, maybe that's one of the things that you do is you try and, buy that other application or registration, or try and enter into some arrangement to coexist with them. So that's one thing I wanted to mention. I will also just briefly mention that, again, this is a hot topic before the office right now, are applications relating to marijuana and CBD products. Currently, the USPTO will not grant registrations for marks that promote marijuana or CBD because these are products banned under the Controlled Substances Act. However, with the prevalence of these products being legal in individual states, there's a lot of pressure on the USPTO to move on this. I'm not sure in what direction they will move or when they will move, if at all, but it is a hot topic and it is something that the USPTO is receiving a lot of pressure about. And then I will also just say in December of last year, there was a new trademark law that was passed, the Trademark Modernization Act, and it is to be implemented by December of this year. And the USPTO is in the process, or should be in the process, of implementing a whole host of rules and regulations to essentially execute the Trademark Modernization Act, or the TMA. And the TMA has a lot of beneficial tools for brand owners. So, and I'll just mention these very quickly, and I'm happy to discuss them offline with those who are interested. There's an enhanced letter of protest procedure. For those of you that are unaware of what a letter of protest is, you can actually write a letter to the USPTO and say, hey, someone has filed this application, and I think it's problematic for these reasons. And the examining attorney overseeing that application is obligated to look at that letter of protest. It doesn't mean they're obligated to sort of adjudge the application based on what the letter of protest says, but they're obligated to read it and consider it. There's also opportunities to challenge registered marks much more quickly than currently. And there's also a presumption of irreparable harm in trademark, a codification of the presumption of irreparable harm in trademark infringement cases. So these are rules that are going to be coming from the USPTO to address the TMA. So I just wanted to mention those things as anticipatory developments and trends in trademarks. Next slide, please. So one thing I wanted to ask you all, given all that we've said, when you all are considering launching a new brand, do you typically select something that is completely new, something that's wholly coined, or do you like to select a mark from existing words? So let me know if the answer is A, you like to create new words or terms, or you typically select marks from existing words. And I will give everyone a few minutes. And I realize this is actually kind of a tough question because it's difficult to create new words. I realize it's hard to come up with new words. So I'm going to quickly look and see. And it looks like it's evenly divided between those who, okay, it's relatively evenly divided with a slight preference for A. So, and I ask this question because these are things that we may have to be thinking more and more about given the depletion and the congestion scenario. And I will say one of the trends that has come up in the effort to create new words or terms is people have been filing applications for marks that use words from another language. So let's just say Chinese or French, and they are using words from another language, but transcribing them into English. So it's not unusual to see a trademark application made from, say characters from another language, Japanese characters, or maybe, Russian, elements from the Russian alphabet. I think that in and of itself is not necessarily new, but the transliteration of words from another language into English is another way that parties are trying to sort of defeat this congestion and depletion issue, because sometimes when you look at a word like that very quickly, it's not immediately recognizable. Sometimes there are, strings of consonants all together, or there is punctuation in a place that you might not otherwise expect it. So that's just, not that I'm endorsing that strategy per se, but that's something that has become a really popular thing to do. So think about, I would encourage everyone to think about what is the best way forward as you select your new brands, whether or not the best way to go is to select new words or terms, if that's possible. Next slide, please. So I'm going to switch gears a little bit here, and I'm going to talk about two cases. And the first case I'm going to discuss is Booking.com. Next slide, please. So before I get into the specifics of the case, I will say, for those of you who haven't heard of Booking.com, what it is a website that allows you to make essentially travel reservations. So if you wanted to book a flight or reserve a hotel, that's what the website allows you to do. And it's very similar to Expedia. So that's one point of context I wanted to share. And what this case is about is a rule that the USPTO had been abiding by for several years. And the narrow rule is when you have a generic term and you add .com to it, you're not really adding to the distinctiveness of the mark or making it any more protectable. Why that's important is that the USPTO has a requirement that you have to have some distinctiveness in a mark in order for it to be registrable. So if something is generic or descriptive, it's not going to be registrable. A generic term is essentially another name for a product or service. And a descriptive term is something that when you see it, there's really not much mental effort that is required to figure out what the underlying product or service is. And so the USPTO had basically said, if you have a generic term and you add .com to it, you're not really adding to the distinctiveness, because .com as well in and of itself was seen as generic. So you were essentially putting together, it was the USPTO's position that putting together two generic components does not create a registrable mark. So that was the backdrop leading up to the Booking.com case. And what occurred was that the owners of the Booking.com mark decided that they wanted to file an application to register Booking.com. And the examining attorney overseeing that application refused registration, asserting that Booking.com was generic. The owner of Booking.com appealed that decision to the administrative tribunal at the USPTO, known as the Trademark Trial and Appeal Board. And the board essentially affirmed the examining attorney's position, basically saying, Booking.com, you don't get to register your mark because it's comprised of two generic components. And again, generic terms are essentially, they're seen to have absolutely no mental distance between, what the word is and what the underlying good or service is. And one of the rules that was in play in the lead up to the Booking.com case is ultimately eligibility for registration turns on what is the primary significance of a mark to the public. So those are all sort of these disparate factual, contextual issues in the lead up to the Booking.com case. So basically at this point, Booking.com has been spurned by the USPTO and it's looking for some relief. And so the owner appealed the USPTO's decision to a court in the Eastern District of Virginia, which actually reversed the USPTO's decision, holding that Booking.com is actually entitled to registration, and the Fourth Circuit upheld the decision. Next slide, please. So then the case was brought to the United States Supreme Court. And this case is actually a big deal in the trademark realm, because I think there aren't that many trademark cases that get to the Supreme Court and sort of reverberate in the way that this case did. And the Supreme Court ultimately agreed with the appeals court decision that said that Booking.com was entitled to be registered as a trademark. And I want to step back a little bit just to give some context and some explanatory sort of flavor to this, because the USPTO's rule about generic plus .com came from a Supreme Court case back in 1888 called the Goodyear case. And the Goodyear case basically said, and this is before Goodyear was decided before the internet existed, as far as I know, basically said, if you have a generic term and you add company, which is also a generic term, then those two things don't together make a protectable mark. So what the USPTO had essentially done is take the logic of the Goodyear case and sort of apply it to a modern day situation where you have a generic term plus .com, which is also seen to be generic, saying that if you put these together, you do not come up with a registrable mark. And the Supreme Court essentially said, we're rejecting this, Goodyear kind of logic where it's a hard and fast rule where if you have this and you put them together, they're not registrable. We're not going to endorse that kind of formalistic, sort of adding together of elements to come up with something that's non-registrable. And again, I emphasize, and I think the Supreme Court emphasized that the Goodyear case was decided long before our current Trademark Act, the Lanham Act. Next slide, please. The interesting thing is that the Supreme Court basically said we can't apply Goodyear anymore because unlike, how things were back when, or unlike when you have company added to a generic term, a domain name or a web address really can only be occupied by one party. So this Booking.com is not something that refers to a whole host of different companies. It's occupied by a particular operator, and that's the operator of the Booking.com website. So we can't essentially use this logic from a case that was decided, years and years, half a century ago or, decades ago. And because of the unique situation where a domain name is only occupied by, one party, we're going to use, the Supreme Court decided there needs to be a different analysis to determine how protectable Booking.com really is. And so the genericness evaluation doesn't turn on, the components of the marks themselves. It's really whether or not consumers understand that the mark as a whole serves as a designation of source for particular products or services, not as a category of offerings. So the court basically says that what do consumers think of when they think of Booking.com? They don't think that it is there is a line in the case that I want to repeat, and I'm not going to do it justice, but basically it says, when you want to make a hotel reservation, you don't say, I'm going to use a Booking.com and I'm going to make a hotel reservation. Typically what you do is you say, I'm going to go to Booking.com, a particular designated place operated by a particular and individual company, to make that reservation. And so the Supreme Court basically says Booking.com in this case gets to be registered because the manner of its understanding by the consuming public is not as a class of services, but as a particular source, a particular origin. This is where you go to get your hotel reservations and your flight bookings. Next slide, please. So I have to ask, what is, the audience's thought on the Booking.com case? Do you agree as to whether or not Booking.com is registrable, or do you not agree? And do you agree with the court's logic? So I'm going to take a look at I'm going to give everyone a few minutes. And I will say again that it is relatively evenly divided between the yeses and the nos. I think that maybe there are a few more yeses than there are nos, but there is no overwhelming majority in the opinions. And I will say, I think I personally am a little agnostic as well on this. I think Booking.com is very, very unique. I don't know how often we come across this scenario. Booking.com is a relatively well-known mark. It's been out there for a long time, or a fairly long time. So I think that there is a case to be made that consumers understand Booking.com as a source of something. But I do think that just adding .com to something may not always make something protectable, but as with all things trademarks, I think this is a situation where it's very, very fact dependent. And so I refrain from making a unilateral judgment, but it is very interesting. And it may actually have real world implications for marks that you all are considering. So you may have been thinking previously that, maybe this is not all that registrable, because I do have a fair number of clients who say, interested in this mark, no, it's not protectable. They sort of start with, no, it's not protectable. No, it can't be registered, but just wanted to talk through like what your thoughts are. So given the landscape change with Booking.com, maybe you all as brand owners will take a different position, or maybe emboldened to register when perhaps you might not have been in the past. Next slide, please. The next case I'm going to discuss is Jack Daniel's versus VIP. Next slide. So this is a total switch of gears. So we're not necessarily, we're not talking about descriptiveness. We're not talking about protectability inherently. We're actually talking about likelihood of confusion with regard to parody works. So the question in this case is a humorous or parody work entitled to the same likelihood of confusion analysis as other products? Just to step back here again, what I mean by that here is that typically, if you are a mark owner, your registration or your rights will preclude others from using the same or similar mark for the same or similar goods or services, typically because that other mark is seen to create confusion in the marketplace. In other words, other parties may think that this junior user is related to you, or that they are licensed by you to use your name and mark. So that's typically the confusion analysis or the infringement analysis. How similar is another party's mark in sight, sound, and meaning in goods and services to your mark? And if it's too close, maybe that's the mark that you as the brand owner decide you're going to write a cease and desist letter about, or file suit on. In this case, there was a company, VIP Products, and they created and sold a dog toy, and it was called Bad Spaniel Silly Squeaker. And it was a toy, deliberately parodying the Jack Daniel's Old No. 7 bottle. And for those who don't know what Jack Daniel's is, I believe it's a whiskey. I could be wrong. It's a form of alcohol in a distinct bottle with a distinct label. And if I'm wrong and it's like bourbon or something else, please correct me. But VIP Products had made this product, and it was deliberately intended to be a funny product, sold as a dog toy. And Jack Daniel's alleged, okay, thank you, bourbon is whiskey, thank you. Jack Daniel's alleged that the product infringed its intellectual property rights. And VIP responded with, actually, no, it's not. It's an expressive work of parody that's entitled to protection under the Fourth Amendment and should be treated differently. And VIP Products cited these factors under a case, Rogers versus Grimaldi. And the Rogers case basically said when you're looking at whether or not a work is entitled to First Amendment protection, you're going to assess two factors: whether that artistic work is relevant to the underlying work, or in this case, the Jack Daniel's bottle, and whether or not this artistic work or this parody work was done with the deliberate intent to mislead consumers as to who made that product. Now, when Jack Daniel's sued VIP, the lower court, the district court, had ruled that VIP had infringed Jack Daniel's trade dress in its bottle. And the case was appealed to the Ninth Circuit. And the Ninth Circuit actually reversed the lower court's ruling and basically held that, lower court, you have to actually affirmatively go through these Rogers factors. You actually have to look at whether or not the VIP toy is not artistically relevant to the Jack Daniel's bottle, and whether or not VIP was intentionally trying to mislead consumers as to who put this bottle out. Or who put this toy out. And I haven't actually I've seen an image of the toy. I haven't seen it for real sale in e-commerce or in a store, but it's pretty evident that it's, this Bad Spaniel Silly Squeaker is intended to be funny. And it's that the real Jack Daniel's, at least to me, didn't have anything to do with it. So the Ninth Circuit, essentially telling the lower court it hadn't properly gone through the Rogers factors, reversed the lower court and sent the case back to the lower court for further decision. and Jack Daniels petitioned the Supreme Court for review, but was denied. Next slide, please. So right now, this question is essentially undecided because the Supreme Court, largely undecided because the Supreme Court has opted not to take up the Jack Daniels case. But really, the question to think about is when you have a product in commerce that is intentionally trying to be a parody work, should it be subject to the same likelihood of confusion analysis to just, a regular commercial product that's being sold? In other words, should such a product of parody be granted heightened First Amendment protection that requires the brand owner to show that this work is not artistically relevant and doesn't explicitly mislead consumers? So in other words, should works of parody essentially have a carve out in terms of whether or not they're infringing? Next slide, please. So I put this question to the group, generally not even the VIP products product, but do you think parody work should be granted heightened protection in the interest of facilitating or protecting that should be expression? Yes, should they be granted heightened protection, or no? And I'll give everyone a few minutes to chime in. Looking through the answers, it looks like it's primarily a yes. Although I have one which is not in the Jack Daniels case. But it seems like most of you have said that you agree with granting parody works heightened protection. And so this is an interesting question because especially during COVID times, there has been an increase in sort of parody type things. So t-shirts and little doodads and knickknacks that are intended to be funny and they're intended to be a play on a pre-existing work. This Jack Daniels case, what predated COVID, but this is something that has become more pressing in the COVID era because there are sort of these funny products intended to help people get through COVID and survive COVID. And that's all they're intended to be, just funny. They're not intended, I don't believe that the makers of these products are intending to ride on the goodwill coattails of a larger brand, but it has come up as an issue. And so right now it's not decided, but it is something that the Supreme Court may take up in the future, I suppose, or it could be something that just comes up more frequently and something to consider. I think there is a thought in the general public that parody works are just protected. And so you shouldn't have to worry about it, but it is something to think about. So with that, that is the end of my presentation. I will say, if you all can take a moment, if you have any questions, to submit your questions using the Q&A feature at the bottom of your window. And if you submitted a question and I didn't have a chance to answer it, please reach out to me. And it looks like we're out of time. And I did want to apologize because halfway through this, my light in my office went out. So I apologize for being in the dark. Thank you, everyone.